My name is Amity Barnard. I'm the special magistrate for this morning's hearing. The first thing I'm going to do, I guess, is ask if there is anybody yet on remotely.
Yeah.
Okay. What I'll do in the meantime, I do believe historically there's been a respondents council that appears on the Zoom, so I expect maybe he'll show up here. But in the meantime, I'll swear everybody in who's going to speak on any items on today's agenda, who's in the room with us. So if you're going to speak, if you could stand if you're able and raise your right hands. Thank you. Do you all swear affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. And then process on this one, I think this is a kind of a status slash fine assessment hearing is sort of my recollection here. But so in this one, I think the process will be the same as for violation hearings, where the town will go first, present any evidence, and then the respondent will then get an opportunity to counter and cross-examine any witnesses. Anybody on the computer, can you hear me? I assume a box will pop up when they appear. Have you had communication with?
I have had communication in the sense that I emailed him and I have received an email from him earlier in the week. I put a call into him on, I think it was Wednesday, but I don't believe I've heard back from him. Maybe we can call him since obviously he would have gotten the Zoom link just recently.
Yeah, and he was present at the August 4th hearing when I ordered this hearing, so he was certainly aware of this hearing. But if he's not on there, it was certainly my understanding that he would be appearing. So if there's an opportunity to reach out, if we could try that. I don't know if, yeah, I don't know if the town has his phone number and can put a quick call into him.
And just for the record, the magistrate, we have, the town does have good service from the property owners, Lantana Holdings LLC. We received their signed green card back.
Yeah, let's hold off on that
Okay.
testimony until if let's just confirm whether there's going to be a representative, and just so he hears all testimony.
Yeah.
Because I had certainly thought, based on the last hearing, that it was his intent to be present here this morning.
Hi, Cody. This is Jeff Kurtz, town attorney for the town of Waxahachie Groves. It was just recently sent to you, probably in the last 5 to 10 minutes. Do you want to check your email? Okay. All right. Take care.
So was that Mr. German, and he is logging in? Is that correct?
Yes, that
Okay.
was his representation that he had received it. He's in the process of logging in.
Okay.
So,
We'll give him a minute to do that.
yeah.
All right, Mr. German, can you hear me?
I can. I'm sorry about that. I just got a call from Mr. Kurtz. He alerted me that the link had just been sent.
Okay, perfect. So just I know who you are, and I can see your face, but can you just state your name for the record, sir?
Yes, Cody German on behalf of the tenant that's operating the kit racetrack.
And what's the name of the tenant again?
Your lawful name is, give me one sec. I know I should know this offhand. Jeff, do you happen to have their legal name in front of you? It's FERP
I believe
Holdings.
it's Herb,
Yeah.
FER.
FERP Holdings.
All right, thank you. And Mr. Gentleman, before you appear, for full transparency, I obviously introduced myself. I swore in the members of town staff who are sitting in the room and explained a little bit about process very briefly. Your case is the only case that's on today's agenda. And the sort of order of process will be the same as it is in all other hearings that you've appeared at, where the town will go first, and then you will get an opportunity to go second and present any evidence or testimony that you have. So with that, I'll turn it back to the town to present and to introduce the case.
Good morning, Code Officer Deanna Thomas, Town of Loxahatchee Groves. This is Lantana Holdings LLC, 16169 Southern Boulevard, Loxahatchee Groves, Florida, 33470. Case numbers 23010003 and 23010006. The violations previously found in violation of code section 87-030 tree removal permit and 20-017 prohibited use. And we do have proper service. We did receive the green card back from Lantana Holdings LLC, the property owner. And if you'd like to see that, I can bring it up to you.
Yeah, I guess in terms of evidentiary case file, are you intending to enter? I guess show me anything that you're intending to enter for today's hearing.
Magistrate Jeff Kurtz, town attorney, as of August 7th of this year. And I mentioned that just because it's been a short time that I have had this role and become familiar with this particular case.
And let me just stop you there quickly. Mr. German, can you hear him? Mr.
I
Kurtz?
can, yes.
Okay,
Thank
very
you.
good. Go ahead. I'm sorry,
Okay.
sir.
That's all right. With respect to this case, procedurally, we're in somewhat of a strange place. There was a stipulation that was entered into by the parties back in 2023. It was then there was a first amendment to the stipulated agreement on July 20th. I'm see July 24th, I think it was, of 2023. There had been hearings before you in April of 2024, and there have been a series of continuances that have led us to today. When I looked back at the proceedings, it seems to me that this has been categorized as a fine assessment / status conference. And one of the issues had to do, I think, with your authority to consider the dissolution of the stipulation. And upon the dissolution of the stipulation, there are a couple of remaining paragraphs, being paragraphs 6 and 7. Paragraph 6 establishes fines retroactive to the date of the amendment related to the use violation. And so that would go back about 786 days at $250 a day. So there's a potential fine out there that's been running or held in abeyance of $196,500 to date. Then there is another fine that is associated with compliance of Article 87, which has to do with the tree violations and the tree removals. It is my understanding with respect to both of those cases, the tree case being the 006, um, and the use violation case being the 003 case, that you've already found them to be in violation. And this stipulation was something that the parties had agreed to and you had adopted as an order. And basically, when I look at these things, it seems to me that the fines were being held in abeyance, subject to the respondent's compliance with the terms of the stipulation. One of the things that I did not find and our code enforcement officer did not find was an affidavit of noncompliance being filed by the town. And that affidavit of noncompliance is the actual trigger for the dissolution of the stipulation and the imposition of the fines. I guess my question to you as the magistrate, because I think you had asked for the briefing on your authority, and the town has filed a response to that. I do not believe that the respondent or Mr. German on behalf of the tenants has filed a response. Our position is that you do have the authority to consider the dissolution of the stipulation, that there has, Your Honor has retained jurisdiction over these matters, and it is able to be brought before you. Once again, the town has not triggered, as far as I could tell from the file. You may have since you've been involved in it, maybe you can say, oh no, Jeff, back in April, we did that. What I saw was there was some testimony with regard to non-compliance, but not an actual affidavit of non-compliance. And those are slightly different. And I don't want to belabor that point. I think it is simple enough for us as the town to enter the affidavit of non-compliance, assuming that Your Honor has considered the issue of whether or not you retain jurisdiction, based on the briefing that was provided.
All right, so with that, I guess let me have you pause there with that explanation. So the certified mails, can I see, is that the only thing you're intending from an evidentiary perspective to enter?
Yes, to show that we do have service, and that although the respondent has not appeared, they were put on notice, and therefore we can move forward with this case.
And what was sent on these was my last order, right, from August 4th. Yeah, okay. So, Mr. German, since you're remote, I presume this was not provided to Mr. German in advance?
Yes.
It was?
Get a copy
Okay.
of it, via email.
Okay, Mr. German, is that correct? You received a copy of the signed certified mail, confirming that the prior order that I issued on August 4th, was delivered?
Yes.
Okay.
The only point I would raise is I'm not sure the notice has been provided to this from the landowner. I just can't speak to that issue. I don't represent the landowner. And I don't know if they've received notice of this hearing.
And let me ask you, because that was the next question I was going to have for you. So what, if this certified mail was sent to you, this was sent to Lantana Holdings LLC, so that is the landowner. The certified mail was sent to them as required by state law, but what is the status of your discussions with Lantana Holdings LLC? I know at prior hearings, they appeared, and my recollection and rereading the stipulations is that Lantana Holdings has waived service of process basically in all future hearings, given the stipulation. So I don't think there's a service issue, but are you still in communication with them or their counsel?
The answer is yes. So, full transparency, my client is a tenant of the property with an option to purchase. The option to purchase actually expires on September 1st. My client has been waiting on an investment in an unrelated business to help fund the acquisition of this property, and that's been tied up. So I'm working with the landowner's attorney to try to deal with that issue in the hopes that my client is able to get some sort of extension on the option to purchase and purchase the property. I think that's the landowner. I can't speak for them, but it's my understanding that that's the landowner's intent and certainly my client's intent to purchase the property. But it does create somewhat of a hurdle in regard to what we're discussing because, I think the landowners, whether or not they're getting notice, I think that they're somewhat uncertain. Do they own this property for the long haul or not? But as we sit here today, they do own the property.
Okay. And do they understand that you're appearing and you continue to appear at these hearings on behalf of the tenant?
Uh, yes, to the
Okay.
best of my knowledge, I do.
Okay. All right. So, Mr. German, I'm going to give you an opportunity. You've heard from Mr. Kurtz. Before I speak at all with regard to the merits, I'd like to hear your side. And I would like to question you. I did not receive the required memorandum that was requested in my prior memo. So I'd like to hear a reason why you didn't submit anything.
The reason is because we're in agreement. My client's in agreement to terminate the stipulation. We're not opposing the termination of the stipulation. Certainly we'd like the opportunity to come back. It's my understanding that the items that were not in compliance are in near compliance, and to come back and address the fines at that point in time.
Okay. All right, just procedurally, let me in the record, for cases 2301-0003 and 2301-0006. I'll enter, the documents that the town has handed me, which include the prior order finding prior order granting continuance dated August 4th, and the, confirmation of, signed certified mail for that prior order having been signed and returned to the town. I'll enter that as composite exhibit 1. Mr. German, you don't have any objection to that entry?
No.
All right, without objection. And let me just. Does the town have a copy of the first amended stipulation?
Yes. Copy of the stipulation and the First Amendment.
Yeah, I have the originals. I just don't have the first amended. Okay, thank you. All right, so let's deal with the service language in the stipulated agreement, just so the record is clear. Not only do we have a certified mail. But paragraph 11 of the fully executed joint stipulation says, by signing this agreement, owner agrees that all procedural due process rights relative to this case are hereby waived. So having been provided a copy of the certified mail of the prior order and also noting paragraph 11 in the joint stipulated agreement, I'm going to find that the town has legally sufficient service for today's hearing. All right, so here's and just this has been going on for quite some time. So, and I had to go back to refresh my memory yesterday of how we got this far into the process. But it was my understanding back in April of 2024, there was a request that the email, though the email doesn't state, I think it was a joint request of both of the parties for a special set hearing, which was held on April 30th to deal with this issue. Obviously that hearing was held and there was an order that came from it. And that was the first order that mandated, that was the first hearing where I questioned my authority, because once the parties take this sort of out of my jurisdiction and you all agree to a joint stipulation, it's no longer my case to essentially prosecute. So my questioning that authority happened back in April of 2024. And then as you noticed, or as you put on the record, there were several continuances granted from April 2024 to ultimately today's hearing. What I don't know is on some of those hearings, there obviously Mr. German was present at I think all of them. I didn't verify that, but I'm nearly certain he was at all of them. But my concern is that we're a year and a half past the first request to have me do something with this, and I don't know why this continued to bump, because now you're saying there's 785 days or whatever it is of potential fines that could have been dealt with pursuant to the joint stipulation. So before I say anything else, what is the ask of the parties of me today? What is the request of the special magistrate today?
You want me?
I'm going to give both of you an opportunity. So I'll let Mr. Kurtz go first, and then I'll let you explain to me what your ask is, Mr. German.
From the town's perspective, I think where we need to get is the understanding of how to move forward. I think that this matter remains within your jurisdiction. I think there is a step, as I indicated, that the town needs to take with respect to the dissolution of the agreement. I think it is a relatively simple step because I don't think there's really any argument that they are in compliance with the terms of the stipulation. So we have to do an affidavit of non-compliance. At that point in time, I think that this order, the existing order, is in essence an order that held the fines in abeyance, but they have been set. I think for clarity, we would probably come back to you to affirm that. And the owner of the property can come in and make an argument as to why that penalty may be too harsh or whatever it is, because, you know, whether it's in the form of a fine reduction or an argument along those lines. As I said, the order with respect to the use case would be on, at this moment, $196,500. The order in the '06 case, which is the tree violation, and our position is that they are still non-compliant with that because we have not received a bond that's associated with the vegetation removal permit. And I will estimate that amount on a daily basis, and it's like a gazillion dollars at $11,452. It's on the order of 50 times the 196, and not probably a gazillion, but probably close to the value of the property. So I would anticipate that they would make some argument as to what that number should be. We haven't had a chance to discuss that, so I don't know what the town's position would be in that regard. But I think we need to move this forward. There was a finding of violation back in 2023. They are still non-compliant. There were these determinations, which, as I said, appears to me to be a holding of the assessment in abeyance, but the assessment was set. So time to move forward. And the other thing that is in this order that survives is a 90-day termination of the use provision 7. I'm sorry, that's paragraph 7. And that calls for them to cease the use and return the property to its previous condition within 90 days of the termination of this stipulation. So it's a very serious matter. I don't want anybody to take it lightly, but I think that's the impact of where we're at. And I can't speak to why steps were not taken to effectuate the termination previously, other than I know that the parties were at one point in time talking about revisions to the stipulation, but that has not come forward, and we've given that process enough time.
Okay, Mr. German, anything you'd like to explain to me about what your ask is to me this morning?
Yeah. So no one has mentioned to me what I just heard as far as terminating the use of this property. That'd be complete news to me, and I can assure you that I would be there and present with witnesses and the like if I knew that that's what they were asking for. What has been relayed to me is that we will terminate, and this is with prior counsel for the town. We've talked about this for a long time. It's been going on for a year. And as someone who's been involved this entire time period, I don't really have a good excuse as to why this has dragged on so long. It hasn't been on the front burner from my client's perspective. Obviously, it's more of a town's position than mine. The issue is we're okay with terminating the stipulation, and we don't agree to any ascertained fine amount today. To table that for another day. If the town wants to try to ascertain what that amount would be, we would deal with it at that point in time. And my client, once this property is put into full compliance, which it's not far from happening, that then we could come back and my client would have the right to seek a mitigation of those fines. That's what my client has been agreeable to all along. The notion that the town now, from what I just heard, which is honestly quite shocking because no one's brought this to my attention, certainly not in writing, not orally, before what I just heard. And the issue of trying to terminate the use of this property, I mean, that would be a serious legal matter of which my client would pursue very aggressively against the town. My client's been obviously able to operate this business for quite some time without the town making such a draconian request, number one. Number two, there's a whole issue as far as how we got here before the stipulation was entered into, the representations made by town officials, and an issue within the town code about the use of this track, of which the town shifted their position. What's been talked about between myself and even Francine and other people from the town who are not there this morning that does figure is that after this property is into compliance, that my client would make a presentation to the town council as far as the town code and regulations and why we believe that this property is already being used in compliance with the code, or whether an amendment needs to be made.
All right. So I guess, Mr. German, I'm a little confused that you're not aware of the use issue, because if you look at the stipulation at paragraph 7, it says, should this agreement be terminated for material noncompliance, the owner shall cease use of and remove all unpermitted improvements from the property within 90 days, or the town may utilize the bond to remove the improvements. This provision shall survive termination of this agreement. So that was an agreed to provision of the joint stipulation, which is remains in effect. So, you know,
Yeah, but Tanya and I, Tanya Early, the prior council, and I were working on a proposed order in that regard, which quite frankly, she had sent to me that didn't have that type of language in it.
okay.
That would have been a good reason to enter into that stipulation, I suspect.
Yeah, so I think
We never refused to.
yeah, there's been a lot going on, and that was my, you know, my concern on cases where there's multiple continuance. This is exactly what becomes the problem, is that you just get the can gets kicked so far down the road that it doesn't benefit anybody. But I guess I just want to read into the record. I think that this hearing is I think, to Mr. Kurtz's point, premature. So I didn't have the benefit of the first amended agreement yesterday when I reviewed all these files, but I just want to read for both the parties that in the First Amendment to stipulated agreement, which is dated June 27, 2023. The paragraph 7 says the parties agree to modify paragraph 6 of the agreement as follows. And number 6, as per now the first amended stipulation, says if owners fail to comply with the with the compliance schedule, the town will record an affidavit of noncompliance in the public records, and this agreement shall automatically terminate and be of no force and effect, except that the provisions of paragraph 6 and 7 shall survive such termination. Additionally, upon the recording of the affidavit of noncompliance, the town will seek an order imposing fines as follows. And then it sets forth very similar language that was in the original stipulation with regard to the 2 different case numbers and the fine amounts for those cases, which I don't think is pertinent here, so I'm not going to read those into the record. But the pertinent part of that language is the part that states, additionally, upon the recording of an affidavit of noncompliance, the town will seek an order imposing fines. So if the testimony this morning is that the town has not recorded an affidavit of compliance, we're not at the point for an order to be imposed. And I think this First Amendment changes, you know, the original amendment in my mind was self-executing and didn't require anything further of the magistrate. It was, you all agreed to this document, and if there was a violation of the compliance schedule, it was an automatic termination once the town recorded the affidavit of noncompliance. I think the language now in section 6, as it's been amended, does allow the town to bring this back to me after the affidavit of noncompliance is recorded. However, the testimony this morning is that has not yet been done, and I have not been provided a copy of that recorded affidavit. I don't think that it is prudent for me to do anything in terms of granting any orders this morning. So I'm happy if the parties, I mean, you can either renotice it, or I'm happy to grant a continuance if that's the request to the next hearing. Or you can simply renotice it, however the town would like to proceed. But I don't think that the case is actually ripe for me to issue an order based on what I've heard this morning.
We would like it to be continued to another date. We're amenable to a special set, or we can put it on not the first meeting in September, but the second meeting in September.
The Wednesday hearing?
The Wednesday hearing.
And I guess I want to speak with counsel for the town more beforehand, because I was not of the understanding whatsoever based on my prior conversations with counsel, including Tanya Early and I believe Ben Sarver, that any agreement to terminate the stipulation in this regard would then be held against my client, saying they need to essentially put the property back to what it was before they conducted significant construction on the property.
Yeah.
Yeah, and I can't speak to obviously the discussions that have gone on outside of these hearings, but I would certainly, the language in these stipulations is pretty severe, to your point, Mr. German. So if there's an opportunity for the parties to get into some agreement, which is what I thought was happening all along, now is the time, because I think after reviewing all of this yesterday, I don't think that the granting of these continuances was beneficial. So in the future, I think I'm going to be a little bit less lenient on that, because I think what ultimately is going to have happened here is a year and a half has gone by, and the same fine amount could have been imposed a year and a half ago, and this would have been done. So I think this one, and I'm sure that there was conversations outside that were trying to come to some agreement, but regardless, the language in the stipulations is what is controlling, because that's what the parties have agreed to. And particularly in the in the First Amendment, your client, Mr. German, joined in on that stipulation. So certainly all the parties were in agreement, at least as it relates to that language. So with that, anything further from you, Mr. German?
No, nothing further from me.
All right, anything further from the town?
No.
All right, with that, in cases 2301-0003 and 2301-0006, having already entered the record and found a legally sufficient notice for today's hearing, I'm going to continue this matter and simply reset it for the September 17th hearing at 9 a.m.
Thank you.
Is someone able to provide with a notice to that hearing? Will there be a separate notice for it?
There'll be there's an order that'll
There'll be an
entered in-
order,
Okay.
yeah. I'll issue an order today that resets the matter for September 17th, and I expect the town can provide you with a copy of that.
Okay.
Okay? All right, thank you, Mr. German.
Thank you. And I appreciate you allowing me to attend remotely.
Of course, thank you. And then this was the only matter on the agenda, so that's nothing further, correct? All right, with that, I will adjourn at 9:38.
Thank you very much.
Thank
Have a good
you.
day.
Would it be possible for you to make me copies of these First Amendments before I leave? I can have this one?
Yes.
Okay, thank you. And there's your paperwork back.
What? See.